The complex nature of the interpretation of the court language and the laws makes it hard for some vulnerable persons, especially the illiterate, to represent themselves in courts of law. Although some people have tried to represent themselves, research indicates that few have managed to win cases due to complications of interpretation, even when it could have been in their favor.
You are convicted of belonging to a terrorist organization.
Those, among others, have prompted many vulnerable persons to give up on seeking justice in courts of law, and some have ended up being robbed of their hard-earned little monies in the quest for seeking for justice. However, some people have opted for other means like mediation and pre-bargaining, among others. Mediation is a process in which disputed parties present their case or argument to a neutral third party to hand them a binding decision that favors both disputed parties. It encourages the parties to look beyond legal rights to their underlying interests and treat a dispute as a mutual problem to be solved by the parties.
It saves time. We see that we do not really pile a lot of cases with court.
Most times, the issues between you and me, and the two of us know where the problem is. We want to unlock that problem at the soonest. That decision is part and parcel of the court decision, and it is enforceable. It can be enforced like any decision made by a judicial officer.
Mediation has not only addressed stigma and discrimination, but also an ear to vulnerable groups in many cases. Role model court mediators have come up openly to offer mediation services, even in cases involving HIV/AIDS.
There is this one dispute I've ever handled. It looked like a land issue, but behind it, there was an HIV-related matter. The brothers got land, inherited land from their father, but one of them was infected with HIV, and the other one felt like, no, this is a walking dead. Why should he be getting land? We had to sit them down, showing them that you're all children, you have equal rights.
A gentleman was HIV positive. They arrested him for trespass, but when trespass was not strong enough for the people who were suing him, they raised it to defilement. Because he was HIV positive, it was going to be aggravated defilement.
However, those carrying out mediation have been faced with various challenges.
People think maybe you've already taken a side, so they feel a bit uncomfortable.
You find that even at the university, the focus is on education.
Some parties come to a mediation and they are not willing to disclose important information that would help in the settlement.
With the above challenges, one wonders how the system can be set up to spread throughout the country and the measures that have been put in place to avoid frustration in another area.
We do some training across the country so that the country is serviced with enough number of mediators. As court, we must have that human approach to appreciating and understanding the circumstances surrounding the case and the parties.
Like the way we've been handling other mediation, we shall try as much as possible to see that HIV people have the same rights, equal rights, like any other person.
Whereas some cases involving HIV/AIDS have been reported in courts of law, there has been a delay in disposing of these cases, which in turn hinders timely justice.
Most people try to shun away from people knowing their statuses, but through the discussions you have, the mediations you keep on conducting, that's when you get the elements.
Some of them are aware of their rights, okay, including disclosing their status. We cannot tell from the face value.
The judicial system really need to come up with trainings to help these judicial officers embrace all matters, even regarding the HIV-related matters.
Okay. First of all, we have the principle of first in, first out. Okay, and there are special categories involving women, children.
Over time, those involved in advocating for the rights of people living with affected by and at risk of getting HIV have tried to come up with initiatives aimed at seeking justice for those people.
When we get out the people who are sick from prison, it's a plus for us, because then we know that in prison they cannot access all the services that they should access.
Although initiatives have been put in place, the implementation has been hard for some of the stakeholders in the justice system.
But what I know, that prisoners try to hide their medicine. Most of them do not swallow the medicine. When we were doing a research in prison, one of them told us that nze simira ddagala ate eddagala olimirira ku mmere kati mira eddagala linzite.
Come out, okay, so that they can be assisted. Number two, institutions to become sensitive about such challenges and accord the necessary interventions.
With an aim to address HIV and AIDS-related cases, the government passed the HIV and AIDS Prevention and Control Act of 2015, which criminalized HIV in the country. Though with the current situation, there are some gaps in the law.
The mischief was that HIV was not treatable at the time when the act was made. And HIV was a death sentence. You got it, you died. But today, people are living with HIV as though they have no problem at all, because there is medicine that sustains life.
But given that these things are coming to light, I think there is need to revisit or review the HIV Act. Find ways of balancing it. We should not discriminate people with HIV. It should not be a standalone.
Unlike in petty and civil cases where mediation is emplaced, capital offences offer the pre-bargain option.
It's a negotiated sentence where you find that the accused or the prisoner now applies to plead guilty to the offense, and punishment of the sentence is negotiated.
I think we haven't handled many sessions. We've overemphasized plea bargain, and people feel like they have to take part in plea bargain if they did not commit offenses as such. You understand? So people end up accepting to have committed offenses, yet in real life they didn't really do that.
The public also needs to understand how to benefit and access the services and the system.
When you come to criminal justice, instead, the treatment is far different. We do not consider that you're sick. We consider that you committed an offense. So a person going to prison, when that person is HIV positive, I want to call it's double jeopardy for them.
So if you come to police and you've committed an offense, so it's up to you to disclose whether you have HIV. Because remember, they're supposed to be taking drugs at a particular time. So all those things need to be looked into.
Since cases involving HIV and AIDS in the country are criminal in nature, stakeholders need to devise means on how to apply some of the fundamental principles in handling such cases.
I think that the problem of criminal justice should be, it's an overall problem, that we have too many people than the system is ready to handle. We get too many suspects, we have too many inmates than the system was ever prepared to handle.
We should embrace a human approach dealing with people who have committed offenses but are also HIV positive. We have to come back on board for the lawmakers to know that a person living with HIV and AIDS is also a normal person who should have the same rights like any other person.
Meeting the demand for timely and affordable legal services is critical to stemming HIV-related human rights abuses in Uganda and elsewhere. As a country, Uganda has come up with initiatives to end HIV, among others, formulating various laws and policies in order to curb the spread of the virus among the people, to promote the rights of those already affected and those who are not yet affected with the virus. The government's target is to see zero AIDS among people living with HIV come the year 2030. Deborah Namamonde, Rose Bukirwaka, UBC News.